What's up, guys? I'm Herbal, and I'm here with another banger. Ah!
And I'm Smalley's, his trusty sidekick.
Right.
So that,
Did you like my new intro with the banger? You see how I was doing the hands?
oh, I didn't catch it actually.
The hands.
Oh, look at you.
I know. I feel like it's a new YouTuber move. At least that's what somebody told me, and that will get
Pro.
me specifically on the right part of the algorithm. And I'm here for it.
You're never getting on the right side of the algorithm, man. You dug that hole way too deep.
Yeah, maybe. So let me ask you something, Smellies. What is a dictator?
A dictator, like a totalitarian, authoritarian. I was gonna say dictatorial ruler, but that's recursive. I guess just someone with absolute and total authority over a country or state.
Yeah, somebody
Is
that
what
can
comes to
make
mind.
decisions, pass laws, and do things without any kind of impunity. I would say is a dictator or a king.
That's something.
You
Yeah.
can also look at it
Yeah.
like that, right? And wasn't the
Hmm.
whole idea of America, right? The founding fathers was that we didn't have kings. In fact, we fought against kings. That was the reason why America became a thing, right? What are the three branches of government, Smellies?
The judicial branch, the legislative branch, and the executive branch.
Good job, Smellies. About 30% of Americans don't know. But these branches of government, the executive being the president, the judicial being, what is that, Congress?
Judicial is the Supreme
Is the
Court,
Supreme
and
Court?
legislative
If it's
is
Congress.
Congress.
Okay. So these three different branches were designed to provide checks and balances to each other so that one wouldn't get more power than the other. No matter what a president has done in the past or will do, he can be prosecuted for criminal actions, right? Now, a president has always had an immunity when doing things in the course of his job, but in a lot of those scenarios where a president's actions are looked into, um, the courts had the ability to actually look into that, right? Now, what the Supreme Court justice, or what the Supreme Court did, was they just passed a ruling saying that the president has absolute immunity when doing things in the course of his office. Okay? Now, we're going to break it a little bit down into what that means specifically. Theoretically, Trump or any president can be prosecuted for things he does outside of the scope of his office. But um,
I
with a
think
little bit
the
of
term of
wordplay and with a little bit of moving things around, anything can be considered in the scope of his office or in the duty or in the scope of his duty as president. We're talking about the immunity ruling that the Supreme Court just ruled on. So,
The other big story in our show today is in our law and justice lead. The U.S. Supreme Court earlier today ruled that Donald Trump is entitled to some immunity from criminal prosecution for acts he took, official acts, when he was president. And now the lower courts must decide which acts are official, which are not, which means that Trump's January 6th case is unlikely to happen before November's election, if at all. CNN's Paula Reed has more on how we got to today's ruling.
Presidents have to be given total immunity. They have to be allowed to do their job.
The Supreme Court partially siding with former President Donald Trump in his ongoing January 6th case, ruling that former presidents are entitled to some immunity from prosecution for official actions, but not for private conduct. In the 6-3 opinion, Chief Justice John Roberts, writing for the majority, at least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law.
but here's the issue, right? What if the president officially orders a SEAL Team 6 assassination of his fucking political rival? Okay,
Yeah.
that couldn't be looked into at all because the president has strict
The
immunity.
High Court, though, leaving it up to lower courts to determine which actions are official and therefore immune. Roberts writing other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public present more difficult questions. Meaning District Court Judge Tanya Chutkan, who is overseeing Trump's January 6th case, will need to decide whether Trump's pressure campaign to get Vice President Pence.
If Mike Pence does the right thing, we win the election.
Georgia state officials.
I just want to find
Oh, that was so crazy.
11,780 votes, which is one more than we have, because we won the state.
And others to overturn the 2020 election results were official acts. Trump celebrating the decision on social media, posting, "Big win for our Constitution and democracy." Justice Sonia Sotomayor dissenting from the majority opinion, writing, "The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law." Something she and other liberal justices warned about during oral arguments in April.
I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
The decision today likely to hamstring special counsel Jack Smith's election subversion case.
Charging Donald J. Trump with conspiring to defraud the United States, conspiring to disenfranchise voters, and conspiring and attempting to obstruct an official proceeding.
Roberts making clear in his majority opinion that Trump's discussions with Justice Department officials and his official conversations with the then vice president are immune. And in another blow for Smith, Roberts says Trump's official acts cannot be considered even as evidence at trial.
So this is like clearly the most like obvious one. Like, what if you went to the what if you went and bribed the president to like pardon somebody to get them out of jail, right, for a presidential pardon? So the act of pardoning the person would be an official act, so you wouldn't be able to question it, right? Maybe the act of receiving the money wouldn't be official, but all you would have to prosecute is, okay, the president received money, and you wouldn't even be able to talk about the pardon. You wouldn't be able to talk about what he did in order to receive the bribe. Like, you would only be able to talk about him receiving money, period.
A trial in this case, though, now highly unlikely before the November election.
But of course, the former president has many other legal cases he is facing. And the next event on his legal calendar is next week, a sentencing in the New York criminal case. Now, sources tell me we can expect Trump's legal team will use today's Supreme Court opinion to attack that conviction. Specifically, they're going to use this opinion to try to get thrown out portions of Hope Hicks's testimony, as well as some tweets that were introduced as evidence. Now, it's unclear if this opinion will be enough to upend that.
Are tweets considered official acts?
And that's what I think what the lower court's going to decide.
But clearly, Jake, today's Supreme Court opinion giving Trump's lawyers a lot to work with over the next few months.
All right, Paula Reed, outside the court, thank you so much. Let's bring in my legal panel. Tim Parlatore, let me start with you. What was your reaction to today's Supreme Court ruling?
It's very similar to what I expected. I wasn't necessarily expecting them to cut it into the three pieces as they did, of the absolute immunity, presumptively immune, and then not immune. But I think that it does make sense to me, based on how it has developed, that they were going to find some form of immunity and then define contours and then kick it back down to the district court to actually have a hearing and figure out how does this rule apply to this case.
Victoria, what did you think?
Well, I was saddened because, they didn't start out the same way they did in the Clinton case or the Nixon tapes case with a very, powerful statement that no one is above the law. They left that till the end. And the court created a lot of doctrine that is entirely new, that's not judicially restrained, in my view, and that the district court's going to have to deal with as to the division between, and your listeners are going to know about
somewhat still alive.
What is unofficial acts, what is private, what isn't. No one thought that if someone does an official statement, or if Obama sends drones, that he can be criminally prosecuted for that. But what about SEAL Team 6?
Right.
What about that hypothetical by Judge Pan in the D.C. Circuit? So he orders SEAL Team 6 to assassinate his political rival. Is that official, or is that private?
Yeah. Tim, how quickly do you think there could be an evidentiary hearing on this matter about what is official, what is not official, what can Trump be prosecuted for, what can he not? How quickly could they call Vice President Pence or Mark Meadows or anyone to the stand to get out this information, grand jury testimony, and evidence?
I think they can do it pretty quickly, and that's the interesting thing about this decision to me. Setting aside the legal precedent of how this is going to affect future administrations, as applied to Donald Trump, both sides are going to kind of get what they want because they can have a pretrial hearing right now, and she can do it very quickly. They already have all the discovery. They just need to get a conference together with the judge and figure out a schedule. Because it's going to be before the judge instead of a jury, you can do it on non-consecutive days. So you can do it 3 days here, 2 days there. And also because it's a pretrial hearing, rules of evidence don't apply, so they can bring in agents to kind of summarize the evidence. They can bring in Mike Pence. They can bring in Mark Meadows. They can bring in all these people. So everything that people are saying, well, we want the American people to know this before the election, that can all be brought out in the pretrial hearing. So everybody who wants it out, they can get what they want. And the people that don't want there to be a trial before the election, they get what they want too.
What do you think of that?
I think it's fascinating, and I think we are going to see Judge Chutkan be asked by Jack Smith to move very quickly. Judges can move quickly.
Do you think there'll be incriminating evidence if during discovery for that trial in terms of the January 6th case?
There might be some interesting sound bites, but I don't know if there'll be anything like earth-shattering.
I honestly, if you would ask me, I think he's going to get away with January 6th. Just the Supreme Court decision says it alone. I mean, is him talking to the crowd, telling them you got to fight? That's considered immune because he was making a speech as a president during that.
My guess is that it'll go back down to the lower court, which it has. They'll find some shit to stick on him that counts as that they find it as unofficial or whatever, and then it'll go to the Supreme Court again when Trump repeals it.
So
appeals it rather.
This is Joe Biden's response.
The presidency is the most powerful office in the world. It's an office that not only tests your judgment, perhaps even more importantly, it's an office that can test your character. Because you not only face moments when you need the courage to exercise the full power of the presidency, you also face moments where you need the wisdom to respect the limits of the power of the office of the presidency. This nation was founded on the principle that there are no kings in America.
Isn't he slurring his speech so far?
Mm-hmm.
Each of us is equal before the law. No one is above the law. Not even the President of the United States. With today's Supreme Court decision on presidential immunity, that fundamentally changed. For all practical purposes, today's decision almost certainly means that there are virtually no limits on what a president can do. This is a fundamentally new principle, and it's a dangerous precedent, because the power of the office will no longer be constrained by the law, even including the Supreme Court of the United States. The only limits will be self-imposed by the president alone. This decision today has continued the court's attack in recent years on a wide range of long-established legal principles in our nation, from gutting voting rights and civil rights, to taking away a woman's right to choose, to today's decision that undermines the rule of law of this nation. Nearly 4 years ago, my predecessor sent a violent mob to the U.S. Capitol to stop the peaceful transfer of power. We all saw it with our own eyes. We sat there and watched it happen that day. Attack on the police, the ransacking at the Capitol, a mob literally hunting down the House Speaker, Nancy Pelosi, gallows erected to hang the Vice President, Mike Pence. I think it's fair to say it was one of the darkest days in the history of America. Now the man who sent that mob to the U.S. Capitol is facing potential criminal conviction for what happened that day. And the American people deserve to have an answer in the courts before the upcoming election. The public has a right to know the answer about what happened on January 6th before they are asked to vote again this year. Now, because of today's decision, that is highly, highly unlikely. It's a terrible disservice to the people of this nation. So now the American people will have to do what the courts should have been willing to do, but will not. the American people have to render a judgment about Donald Trump's behavior. The American people must decide whether Donald Trump's assault on our democracy on January 6th makes him unfit for public office in the highest office in the land. The American people must decide if Trump's embrace of violence to preserve his power is acceptable. Perhaps most importantly, the American people must decide if they want to entrust the president once again, the presidency, to Donald Trump, now knowing he'll be even more emboldened to do whatever he pleases whenever he wants to do it. You know, at the outset of our nation, it was the character of George Washington, our first president, to define the presidency. He believed power was limited, not absolute. And that power always resides with the people, always. Now, over 200 years later, with today's Supreme Court decision, once again, it will depend on the character of the men and women who hold that presidency that are going to define the limits of the power of the presidency, because the law will no longer do it. I know I will respect the limits of the presidential powers I have for 3.5 years.
God damn it!
But now,
do you see? Like, this is what I don't need you to do, Joe. I think there is a really good chance that Trump wins, just for that debate performance and his performances here on after. Yeah. Okay? Just for that fact. Because he's losing a lot of faith. Exactly. And it's scary because we've never swapped out, you know, a fucking presidential candidate this close. But the DNC, when is the Democratic National Convention?
I don't know, in a month or two.
It might be the craziest DNC you guys have ever seen. Okay, but this is Biden's reaction to Trump's to the Supreme Court immunity ruling, right? So Biden is pretty much sticking with what the liberals are saying, which is that, you know, this defeats the whole purpose of why we have become a country, or why we became a country. Okay, we are a democracy where nobody in the land, nobody is above the law. But this ruling puts the president ostensibly over the law. Anything that he does he's immune to. He can traffic cocaine, and if it's for money to go to the fucking government, like if it's a governmental action, he can order the death of people. If it's a governmental action, he can order whatever he wants, or if he says it's a governmental action, right? Like, this kind of power is literally absolute power. And we know what they say in Star Wars, right?
Perhaps they're all remembering that old saying, power corrupts. And absolute power corrupts absolutely.
Absolute power corrupts absolutely. But I have another video. This is Legal Eagle, okay? So he's going to break down exactly what this legal decision means in a little bit more layman's terms.
However bad you think it is, it's worse. Remember when Trump's lawyers argued that he could SEAL Team 6's political rivals, and we all laughed because that's a preposterous thing for anyone to argue, and absolutely no serious person could possibly believe that the Constitution or the laws of this country would allow that to be the rule. Well, the Supreme Court just said, hold my beer while I assassinate my political rivals.
The president is entitled for total personal gain to use the trappings of his office. That's what you're trying to get us to hold.
Yes, the Supreme Court has effectively given law-breaking presidents, and we're not singling any one law-breaking president out or anything, could be any felonious president, almost absolute immunity from criminal prosecution. And where the court did not grant outright absolute immunity, it gave presumptive immunity and procedural protections that might as well have been absolute immunity. And while unofficial acts of the president still receive no immunity, the crap cherry on top of this crap sundae is that even though a president now has immunity from criminal prosecution for official acts as president, a prosecutor cannot even use official acts as evidence in a prosecution over unofficial acts, which makes prosecution of some unofficial acts virtually impossible. Whether you are a Republican or a Democrat, this is a terrible decision for democracy, possibly a top 5 worst Supreme Court decision of all time. Happy July 4th, everyone! But just how bad is it? Well, don't take my word for it. Justice Sotomayor says, quote, the court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country and possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy's SEAL Team 6 to assassinate a political rival? Immune. Organizes a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Justice Sotomayor concludes that the opinion marked a sea change in the relationship between the people and the president. Quote, in every use of official power, the president is now a king above the law. But how did we get here? Well, until now, executive immunity was a court-created doctrine that shields presidents from most civil lawsuits involving conduct that occurred during their presidential terms. There's no explicit constitutional text granting the president immunity, but in Nixon versus Fitzgerald, the Supreme Court ruled that a president is entitled to absolute immunity from legal liability for civil damages based on his official acts, including acts on the outer perimeter of his duties. The court defined the president's official duties quite broadly to prevent future presidents from being sued for, quote, virtually every allegation that an action was unlawful or was taken for a forbidden purpose.
Yeah, so that's like if the president does something that maybe fucks over your business, like the, coronavirus shit, you can't sue the president for, taking your business down because of, he forced you to fucking shut down. Which, it's nothing anybody ever, disagreed with. But, they wanted to take it a step further, specifically for Donald Trump. And, people say Trump derangement system is a thing, but this motherfucker is literally destroying the country, okay? He's coming in, he's fucking with laws, because he has a fucking vice grip over the dumbest fucking party in the country, okay? If you look at the debates, do you guys think that Hillary Clinton came with less facts than Donald Trump?
Donald, I know you live in your own reality, but that is not the fact. I think you've just seen another example of bait and switch here. So you've got to ask yourself, why won't he release his tax returns? And I think there may be a couple of reasons. First, maybe he's not as rich as he says he is. Second, maybe he's not as charitable as he claims to be. Well, as soon as he travels to 112 countries and negotiates a peace deal, a ceasefire, a release of dissidents, an opening of new opportunities in nations around the world, or even spends 11 hours testifying in front of a congressional committee, he can talk to me about stamina. He tried to switch from looks to stamina, but this is a man who has called women pigs, slobs, and dogs.
Right? Do you think that any of the other fucking Republican candidates came with less facts than Donald Trump? No. How Donald Trump got to power is because we're slowly living in the fucking idiocracy universe.
And mankind became stupider at a frightening rate. Some had high hopes that genetic engineering would correct this trend in evolution. But sadly, the greatest minds and resources were focused on conquering hair loss and prolonging erections.
And instead of a motherfucker knowing his shit and able to debate well and able to speak well and able to fucking be an actual politician, you just have a dude that makes fart fucking jokes and fart noises and fucking fart noises and toilet humor. That's all he does, okay? All he does is make jokes.
He always finds a way to win. And when he's back in our White House, America is going to start winning again.
He's got a higher IQ than any man alive. He's going to fix everything.
The price of food and gas and housing is out of control. And the only person who can clean this up is Donald Trump.
He'll fix the problems with all the dead crops. He's going to make them grow again.
He's going to win in November, and we're all going to be champions again when he wins.
I give you my word. He's going to fix the economy.
Let Trumpomania run wild, brother. Let Trumpomania make America great again.
That's what I thought.
He can be a Twitch streamer, not the fucking president, okay? And that's all you do. You have this old motherfucker that makes jokes and just tells lies, and then you have idiots that believe him, right? Again, say what you will about Joe Biden being super old and unable to fucking... The team behind Joe Biden kicks ass. The motherfuckers that are playing him like a fucking puppet doll are fucking killing it, okay?
The court explained that it was, quote, settled law that the separation of powers doctrine does not bar every exercise of jurisdiction over the President of the United States. To determine whether a particular type of suit against a president or a former president could be heard, a court must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. Indeed, in Clinton versus Jones, the Supreme Court found that under that rubric, the president does not have immunity from civil suits for conduct before they became president. So until now, virtually every lawyer and judge in the country assumed that while executive immunity would shield civil lawsuits because the president could be sued by almost anyone in the country over almost anything, that criminal prosecutions would be different. Why? Because it's way more important that a president be bound by criminal law and not commit heinous criminal acts, even in service of their duties. Plus, there are way more safeguards against criminal prosecution than civil suits. But Trump moved to dismiss his D.C. prosecution on immunity grounds. He lost at the trial court and appealed the decision. Judge Tanya Chutkan stayed the criminal proceedings pending the outcome of the appeal. The D.C. Circuit upheld the lower court's ruling that, quote, former President Trump has become Citizen Trump with all the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. The Circuit Court ruled that presidents are not above the law. Quote, the president has a constitutionally mandated duty to take care that the laws be faithfully executed. As part of this duty, the president is responsible for investigating and prosecuting criminal violations. It would be a striking paradox if the president, who alone is vested with the constitutional duty to take care that the laws be faithfully executed, were the sole officer capable of defying those laws with impunity. The Circuit Court's decision was widely praised as a well-constructed opinion that came to the only logical conclusion. But then it arrived in the Supreme Court. The top-line ruling from the majority of the Supreme Court is this. Presidents cannot be indicted based on conduct for which they are immune from prosecution. Based on the standard that this opinion creates, which we'll talk about in a second, Justice Roberts, writing for the 6-justice majority, kicked things back down to the trial court. Quote, on remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they, too, involve conduct for which a president must be immune from prosecution. And so how do we determine if the president's action is part of their core responsibilities or not? Well, we don't know. There's no standard in this opinion. They are apparently, according to this court, whatever powers the president has that are not shared with other branches of the government. But it's not like those powers are just listed in the Constitution. And other than the few powers that were explicitly enumerated by this court, including removing people from office and commanding the military, we have no idea what might be considered a core power or not. But even those enumerated core powers are terrifying, because the court specifically said commanding the military. So if you take one thing away from this video, it's this. Because commanding the military is apparently a core presidential power, and use of core presidential power is absolutely immune from criminal prosecution, any use of the military by the president, including using the American military on American soil, is absolutely immune from criminal prosecution. And if you take two things away, it should be that the president can do anything related to the DOJ, create sham investigations, sham prosecutions, fabricate evidence. They can do any of that, and they are absolutely immune because that's a core function. And a few really good commentators put it this way. The office of the president is like a gun. When you get elected president, you have an unfettered right to use that gun any way that you want to. Your motives and purposes for using that gun are completely irrelevant. You're the president, use the gun however you want. Criminal law does not apply to your use of that gun. And that is why multiple Supreme Court justices are concerned about a president SEAL Team 6ing their political rivals. But some official acts are only presumptively immune. So how would a prosecutor overcome the presumption of immunity that comes with non-core official acts? Well, again, we have no idea. The court doesn't provide a standard. The only thing the court says is that, quote, at a minimum, the president must be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to that act would pose no dangers of intrusion on the authority and functions of the executive branch. This is barely a limit. There's almost no reason to distinguish between core and non-core official acts if there's no limit on what can be an official act that receives immunity. This language is from the original Fitzgerald balancing test, but turned on its head. Instead of balancing the importance of the intrusion, the court simply says if there's any danger at all of intrusion, there is immunity that attaches to that action. As Justice Sotomayor said in her dissent, quote, no dangers, none at all. It is hard to imagine a criminal prosecution for a president's official acts that would pose no dangers of intrusion on presidential authority in the majority's eyes.
This is fucking terrifying, bruh. Especially if you have a dude like Trump who just doesn't give a fuck, just in office. Like, he would order the murder of his fucking political rivals. he would order just like, evidence that, like, literally just throw Hillary Clinton in fucking prison because he wants to, right? If he gets back into power with this kind of fucking unlimited access, bro, the thought is fucking terrifying. What he can do. It's fucking terrifying. It's we're going into literal dictatorship mode.
I don't disagree.
Nor should that be the standard. Surely some intrusions on the executive may be justified by an overriding need to promote objectives within the constitutional authority of Congress. Other intrusions may be justified by the primary constitutional duty of the judicial branch to do justice in criminal prosecutions. According to the majority, however, any intrusion on executive power is too much. When presumptive immunity is this conclusive, the majority's indecision as to whether official acts immunity must be absolute or whether instead presumptive immunity is sufficient hardly matters. Now, I've seen a few legal pundits say that this decision is no big deal because immunity only attaches absolutely for the exercise of core presidential powers, despite the fact that the military is almost certainly a core power and lets the president drone strike their rival. But it's okay because other official acts are only presumptively immune and therefore can be prosecuted. But based on this language, that's not the case. Given that the only official acts that can be prosecuted are ones where there is absolutely no danger of intrusion into the authority and functions of the executive branch, that category is vanishingly small. Worse, you can't look to the president's motives to determine whether the act was official or not. Now, even if you're president and you murder your political rivals and receive protection, you'll still want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've
I appreciate you, bro. Nope.
Or dealing with a worker to talk to a lawyer or call the number on. Okay, sure. But unofficial acts are not immune, right? Well, hold on. First, how would we distinguish a president's official actions from his unofficial ones? Well, the court says, quote, when the president acts pursuant to constitutional and statutory authority, he takes official action to perform the functions of his office. However, the court then says that official acts are not constrained to the president's constitutional and statutory authority. The majority says, quote, and some presidential conduct, for example, speaking to and on behalf of the American people, certainly can qualify as official conduct when not obviously connected to a particular constitutional or statutory provision.
So him talking to the fucking crowd on January 6th is considered immune from prosecution.
For those reasons, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. So, if you think that sounds like a very broad description of presidential official acts, you'd be right. I would be challenged to come up with a broader definition. But surely plotting to overturn an election result would be manifestly and palpably beyond the president's authority, right? Wrong. The Supreme Court said, quote, in dividing official from unofficial conduct, courts may not inquire into the president's motives. According to Roberts, even asking the question would cripple the executive branch's ability to function. And it gets worse. According to Justice Roberts, quote, nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. So if a president's action violates a law, that doesn't mean he can be prosecuted.
Well, when the president does it, that means that it is not illegal.
As Justice Jackson points out in her dissent, the government will have difficulty proving whether an act is official or unofficial since it can't introduce evidence of the president's motives. That's right, the court says you can't look to the president's motives to determine whether an act is official or unofficial either. You know, for reasons. The only question is whether the president has the power or not. And Justice Jackson points out the problem with this means-only or authority-only approach in her dissent in a footnote. She says, quote, to fully appreciate the oddity of making the criminal immunity determination turn on the character of the president's responsibilities, consider what the majority says is one of the president's conclusive and preclusive prerogatives, the president's power to remove those who wield executive power on his behalf. While the president may have the authority to decide to remove the attorney general, for example, the question here is whether the president has the option to remove the attorney general by, say, poisoning him to death. Put another way, the issue here is not whether the president has exclusive removal power, but whether a generally applicable criminal law prohibiting murder can restrict how the president exercises that authority. And the implied answer in that footnote is that the president is free to poison any member of their staff or cabinet because they have authority to remove that person. They've got the power, so any means whatsoever would be an official act. And I'm not being histrionic here. Justice Sotomayor says the majority allows the president to send SEAL Team 6 to kill their political rival. Justice Jackson says the majority allows the president to poison any member of their staff. This isn't just me. These are the dissenting justices on the Supreme Court. This is what I meant when I said this was bad. And this policy argument on which they 100% rely stems from the idea of separation of powers. But it also turns that idea completely on its head, because part of separation of powers is checks and balances. And here, they've organized things in a way that the executive is completely unchecked by either of the other branches of government. And while the majority opinion is 43 pages long, it never got around to defining unofficial acts. So while it provides tons of guidance on what is an official act and is therefore immune from prosecution, they give zero guidance whatsoever on what is an unofficial act and therefore would be prosecutable. All we know is that official acts which are immune are anything within the outer perimeter of the president's official responsibilities, covering actions so long as they are not manifestly or palpably beyond his authority. That's almost anything a president does. So the court has also made the official versus unofficial distinction almost meaningless. As Justice Sotomayor says, in fact, the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. It says that whenever the president acts in a way that is not manifestly or palpably beyond his authority, he's taking official action. It then goes a step further. In dividing official from unofficial conduct, courts may not inquire into the president's motives. It is one thing to say that motive is irrelevant to questions regarding the scope of civil liability, but it is quite another to make it irrelevant to questions regarding criminal liability. Under that rule, any use of official power for any purpose, even the most corrupt purpose indicated by objective evidence of the most corrupt motives and intent, remains official and immune. Under the majority's test, if it can be called a test, the category of presidential action that can be deemed unofficial is destined to be vanishingly small. So to help understand all of these distinctions, the great people over at Justice Security put together this great chart. Starting from right to left, if there is official conduct, we have to ask, is it within the core constitutional authority? If it is, there's absolute immunity, no prosecution, and you can't use it as evidence. If it's not core constitutional authority, you have to ask, does it pose any danger of intrusion on the authority and functions of the executive branch? If it does, no prosecution, can't use it as evidence. If it doesn't pose any dangers of intrusion on the authority and functions of the executive branch, then there is no immunity and you can use it as evidence in a prosecution. Then going back up to the top of the chart, if the conduct is 100% unofficial, then yes, you can prosecute it. But remember, you cannot use any official acts or anything that was deemed an official act as evidence in that particular trial. Now, when courts address constitutional questions, they're generally bound by principles of judicial restraint. Now, the consequences of this decision are not just about...
Have you heard of the false electors? Smellies?
What about false electors?
So, basically Trump had a bunch of false electors come up, and hold on, you haven't heard of like the January 6th false electors?
Now charged with his second set of federal crimes. He'll face a judge tomorrow as part of the special counsel's investigation into a plot to illegally overturn the 2020 election to try to keep Mr. Trump in power. A key part of it all, the so-called fake elector scheme. You may have been hearing about it, right? People talking about it, throwing off the phrase fake electors, etc. But in tonight's breakdown, we're explaining what a fake elector is and how this unfolded. You probably know how a presidential election works. Voters in all 50 states head to the polls to choose who they want as president. If enough voters back a certain candidate, that candidate gets electoral college votes from that state. The winner needs 270. That's the magic number.
Here's the road to 270.
So that's what you see on TV. You typically don't see what happens next because it's usually a formality as members of the electoral college pick it up from there. Those members, called electors, are selected by state parties months before Election Day. After every presidential election in December, each state gathers together electors from whichever party won the popular vote in that state. Those folks meet and send an official certificate to the National Archives and to Congress. They look like these, and they basically say, okay, this is who gets our state's electoral college votes. It's pretty ceremonial. Except in 2020. That's when the former president and his allies got to work convincing loyalists in 7 states that they should back Republican electors in key battlegrounds won by the Democrat in the race, Joe Biden. The focus on Arizona, Georgia, Michigan, Nevada, Wisconsin, New Mexico, and Pennsylvania. Some of those so-called fake electors showed up at state capitals where the real electors were meeting. They even created phony certificates like the ones you see here. The goal, apparently, to send through this fake slate of electors to Congress, where the vice president presides over the official count. The thinking seemed to be that then VP Mike Pence could grant Mr. Trump the disputed electoral votes or send the issue back to the states, opening the door to keeping Mr. Trump in power. You probably know what happened next. Pence rejected the scheme, citing the Constitution.
President Donald J.
See, so that's when Trump says, like, Mike Pence, he has the ability to say no. He has the ability. What he means is, right, like, he can reject those fake electors And in doing so, he basically basically sends it back to be decided by is it decided by the Supreme Court, which is like a Republican majority. Anyway, yeah. So the fake elector scheme is one of the ones that is one of like the most like, I think, obvious signs of a coup. All right, it wasn't just like I told my crew. It was literally you had fake motherfuckers going to the Capitol.
Text from Federalist 70, and that's about it. You apparently can't have any enfeeblement whatsoever of the president, even though every president for the last 250 years has assumed they could be criminally liable for at least some of their conduct. But that's it. That's all the support they have. It's just a policy argument that a vigorous, unencumbered presidency is good, therefore almost full immunity. QED, from proclaimed originalist and textualist, this is honestly shockingly dishonest and hypocritical. Because we're dealing with the Constitution, Congress can't pass a law that says the president will be criminally liable for virtually anything, and the judiciary can't prosecute the president, so the president is unchecked. And the majority opinion doesn't even address the public's interest in not having a criminal president. As Justice Sotomayor points out in her dissent, the court's precedent suggests that presidents do not and should not have broad immunity from criminal law. Quote, at the same time, the public interest in federal criminal prosecution of a former president is vastly greater than the public interest in a private individual's civil suit. All 9 justices in Fitzgerald explicitly recognized that distinction. The 5-justice majority noted that there was a greater public interest in criminal prosecutions than in actions for civil damages. Chief Justice Berger's concurrence accordingly emphasized that the majority's immunity was limited to civil damages claims rather than criminal prosecution. The 4 dissenting justices agreed that a contention that the president is immune from criminal prosecution in the courts, if ever made, would not be credible. And the ramifications of declaring the president above criminal law are huge. Justice Jackson explains, quote, put simply, immunity is exemption from the duties and liabilities imposed by law. In its purest form, the concept of immunity boils down to a maxim, the king can do no wrong, a notion that was firmly rejected at the birth of our republic. And as Justice Sotomayor explains, quote, the majority makes 3 moves that, in effect, completely insulate presidents from criminal liability. First, the majority creates absolute immunity for the president's exercise of core constitutional powers. This holding is unnecessary on the facts of the indictment, and the majority's attempt to apply it to the facts expands the concept of core powers beyond any recognizable bounds. In any event, it is quickly eclipsed by the second move, which is to create expansive immunity for all official acts. Whether described as presumptive or absolute under the majority's rule, a president's use of any official power for any purpose, even the most corrupt, is immune from prosecution. That is just as bad as it sounds, and it is baseless. Finally, the majority declares that evidence concerning acts for which the president is immune can play no role in any criminal prosecution against him. That holding, which will prevent the government from using a president's official acts to prove knowledge or intent in prosecuting private offenses, is nonsensical. Argument by argument, the majority invents immunity through brute force. Under scrutiny, its arguments crumble. To start, the majority's broad official acts immunity is inconsistent with text, history, and established understandings of the president's role. Moreover, it is deeply wrong even in its own functionalist terms. Next, the majority's core immunity is both unnecessary and misguided. Furthermore, the majority's illogical evidentiary hearings is unprecedented. Finally, this majority's project will have disastrous consequences for the presidency and for our democracy. The main takeaway of today's decision is that all of a president's official acts, defined without regard to motive or intent, are entitled to immunity that is at least presumptive and quite possibly absolute. Whenever the president wields the enormous power of his office, the majority says the criminal law, at least presumptively, cannot touch him. The official acts immunity has no firm grounding in constitutional text, history, or precedent. Indeed, those standard grounds for constitutional decision-making all point in the opposite direction. No matter how you look at it, the majority's official acts immunity is utterly indefensible. Now, the 6 conservatives in the majority, all of them self-described strict textualists, were really offended by this comment. They say that, quote, a specific textual basis has not been considered a prerequisite to the recognition of immunity. And Justice Roberts tries to rebut Sotomayor by noting that the Constitution is silent on all matters related to prosecuting ex-presidents. Quote, conspicuously absent is the mention of the fact that since the founding, no president has ever faced criminal charges, let alone for his conduct in office. But that's entirely Sotomayor's point. She says the Constitution's silence is noteworthy in at least 3 respects. Quote, first, the framers clearly knew how to provide for immunity from prosecution because they did give narrow immunity to legislators via the speech or debate clause. She says, quote, they did not extend the same or similar immunity to presidents. This is classic textual interpretation. If you're bound by the Constitution and the Constitution grants immunity in some places, but is silent as to immunity in other places, that immunity doesn't exist. Her second point is that some state constitutions did provide express immunity for sitting governors, but the Constitution did not. Again, calling into question the reason the framers did not extend that privilege to a sitting president. And the third contention was that the impeachment judgment clause cut against the court's position. Quote, that clause presumes the availability of criminal process as a backstop by establishing that an official impeached and convicted by the Senate shall nevertheless be liable and subject to indictment, trial, and judgment and punishment according to law. That clause...
Jesus, bro.
I have Judge Sotomayor's signature.
Really? She's fucking amazing.
Yeah, I wrote her a letter when I was in middle school.
Damn.
Clearly contemplates that a former president may be subject to criminal prosecution for the same conduct that resulted or could have resulted in an impeachment judgment, including conduct such as bribery. So there's no other way to put this. This is a horrifying opinion. And I personally worry about the future of this country. For one reason, we can't change this. There's no one to appeal to. Congress can't fix this with legislation. We can't appeal to the courts because the highest court in the land says that the immunity exists and it's almost always absolute. The Constitution is the highest law of the land, and it's effectively like the Supreme Court has amended the Constitution to include an immunity that has never existed before with zero basis in the text and history of the Constitution. All we can do is hope that future presidents won't use this power. This is horrifying not only for those that think former President Trump committed crimes while in office, but for anyone that believes the president should be bound by the law. As of today, for many actions, regardless of their inherent criminality, the president is immune. And even if you believed every crazy thing that has been alleged about Biden and the Biden crime family, this decision would immunize almost every allegation that has been levied against them. And of course, the shadow of Trump's actions looms large, but I wouldn't want this opinion to come down during any presidency. Nor does any serious jurist think that this should be the law going forward. No president should have this immunity. No president should have this power. And perhaps someday the Supreme Court will scale back this opinion and provide reasonable definitions. But as it stands now, current and future presidents have the powers of a king. So yeah, this is bad, and I frankly can't think of anything worse. And that's also reflected in the news reporting as well. What's interesting is that the Supreme Court decision has been covered extensively by over 400 news outlets, 33% of the reporting coming from the left and only 17% coming from the right. But if you compare the headlines, you'll start to see some interesting framing emerge. On the left, you have a lot of outlets saying that Trump was granted immunity. On the right, outlets tend to draw the distinction between official acts and private acts. And depending on which article you see first, your view of the story can be completely different. If you read the left-leaning sources first, you might think that presidents have complete immunity and only focus on the potential negative outcomes, which frankly is more accurate. And if you read the ones on the right, you might fail to see any of the potential repercussions from this decision. Now, all this is possible thanks to today's sponsor, Ground News, a website and app developed.
So, we're going to live in the dictatorship, Smellies. You ready?
Oh, yeah. Locked and loaded.
I honestly think, and again, the only reason why they're doing this is because of Trump. He's literally changing our country. Just the fucking pillars that our country was built upon. He's fucking tearing them down, and the Republicans are cheering him doing it because they're mad about brown people. My whole thing is this, right? Like, when looking at the president of the country with the strongest military in the world, if you want to say that's the strongest, that's the most powerful man on the planet, you might not be too far off the mark. And you're giving this man absolute immunity to do things like accept bribes, murder political opponents. And what's scary enough is we have a motherfucker on the ballot that is crazy enough to do it. Okay? Say what you want about fucking Biden, right? At least with Biden, he won't be able to just say something like, hey, you guys either vote my way or I kill you all. And because you're my constituents and I'm talking to you, this is an official act. Right? It's fucking terrifying. So I honestly feel if you have Trump come in under this kind of immunity, he's not leaving. He's not coming out. Not after 4 years, not after 10 years. He's not coming out till he's dead. And he might pass a law saying, hey, after I die, my daughter takes my place or my son takes my place. And then you have America officially changed into a fucking dictatorship, just like they see in the movies. Okay? When you have a person that is this unable to be touched, right, what can you do? He can literally kill you and has immunity from it. Terrifying.
Mm-hmm.
Anyway, thank you for joining me, Smellies.
Yeah.
Thank you guys for watching. I stream on Twitch, twitch.tv, HerbalRemedyS, and on Kick. Check that out, kick.com/HerbalRemedyS if you want to watch some Ratchet TV. Hit that like, hit that follow, hit that subscribe. Check out my other videos. You guys have been awesome. Thank you for tuning in, and I will catch you on the next one.